In this video, we will be discussing well-known trademarks. We will see what are well-known trademarks and their impact. And we will try and understand this term well-known trademarks in the context of Enfield India Ltd versus Deepak Engineering Syndicate. Now, Section 21ZG of the Trademarks Act 1999 defines what is known as well-known trademark. Now, according to Section 21ZG, a well-known trademark in respect of any goods or service means a mark which has become so well known to a substantial segment of the public which uses such goods and services that the use of such mark in relation to other goods and services would likely to be taken as indicating a connection in the course of using these goods and rendering these services between those goods and services and the person using the mark in relation to the mentioned goods and services. So, a well-known brand is so well known amongst the general public that if someone else manufactured a different product but used the brand, it would mean that people would imply that that new product is manufactured by the person who held the trademark. So that is what Section 21ZG talks about, the well-known trademark. Now, let's look at the facts of the case. In 1985, this company, Messrs. Deepak Engineering Syndicate, went to the assistant trademark, that's the first court where a trademark case is filed, went to the assistant registrar and said that we manufacture diesel oil engines and parts of those engines. We have been using the name Bullet since 1979. Of course, Enfield India, which manufactures the Bullet, objected to this. However, they lost the case, and the assistant registrar, held in favor of Deepak Engineering Syndicate. Therefore, Enfield went into appeal under Section 9, 11A, 11E, 12(1), and 18 of the Trademarks Act. So now the matter is before the IPAB, the Intellectual Property Appellate Board. The appellant being Enfield India, because the patent of Bullet, the trademark of Bullet, was given to Deepak Engineering Syndicate. Now, what was Enfield India's case in the appellate tribunal? It said that it is a registered proprietor of the trademark Bullet. All these registrations are for motorcycles. Bullet motorcycles from Enfield India are well known amongst the public, and they have achieved distinctiveness in their products. They said that the registration of identical marks by Deepak Engineering Syndicate in respect of the diesel oil engine would create confusion in the mind of the public as well as in the minds of their trade channels. And therefore, they filed an appeal under Section 11A of the Trademarks Act. Enfield India said that the assistant registrar gave Deepak Engineering Syndicate the trademark for Bullet on the grounds that number one, the goods were different. Two, Section 12(1) was not attracted. We will see what Section 12(1) is later on. The trade channels were different, and therefore there cannot be any confusion. Now, let's look at what Deepak Engineering Syndicate said in the appellate tribunal. They said that Their goods are not motorcycles, their goods are diesel engines, diesel oil engines. These are used for agricultural purposes. Their customer base are agriculturists, and the appellant's products, that is Enfield India, their products were motorcycles which were completely different from Deepak Engineering, Deepak Oil Engines. They also further said that there is no evidence to show that there is a confusion regarding the use of the trademark bullet for the oil engines and for the motorcycles. Now, what did the IPAB hold? Let's look at Section 11A. Section 11A states that it rather prohibits the registration of a mark if the use of that mark would cause deception or confusion. Now, the IPA relied on three judgments, which we will see later on, but what these judgments held. The sum and substance of these three judgments were that if there's a possibility for the consumer to think that he is purchasing from the appellant's factory by virtue of similarity of the trademark, that in itself will show that there is confusion and deception, even though the product is different. Now, the cases relied on were Daimler-Benz versus Haibo Hindustan. Now, we all know that Daimler-Benz is the maker of Mercedes-Benz cars. Haibo Hindustan is the manufacturer of undergarments, and they came out with the product Benz. Of course, Daimler-Benz took them to court, stating that, see, we own the trademark for Mercedes-Benz, our cars are well known. You cannot use our trademark on your undergarments. The court held in favor of Benz. In the same fashion, the court held in favor of the other two companies in this matter. So, what did the IPAB conclude? It concluded that a well known mark cannot be permitted to be copied by another, even if the goods are different, even if the goods belong to different classes, because there will be some confusion caused in the minds of the public with regard to the source of production. Now, the person who adopts the well known trademark will definitely take advantage of the reputation of the well known mark, and this the IPAB held that it cannot be permitted. The IPAB held that Enfield is the company's name, Bullet is their trademark used to identify their motorcycles. Enfield Bullet has its own distinctiveness in respect to their product, that is, motorcycles. They said that a bullet has been supplied to army personnel, police personnel, people in villages in rural India. If they have a bullet, it's a source of pride for them. So they concluded that when much of a reputation has been built by the appellant in respect of their motorcycles having the trademark Bullet, the use of the same mark by any other individual for any category of good would definitely create some confusion in the minds of the general public, and thus Deepak Engineering Syndicate could not get the trademark of Bullet. The IPAB held against the order of the assistant registrar. Thus, the appeal was allowed.